the law student. Now, if you go further, 3 is saying without limiting subsection 2, the assessment of the law program shall include. So it will be the assessment of the law student shall include a variety of assessment method appropriate to the nature, level, and objective of the law student. You understand? Because it is the program that have objective. The program objective. So if you read it in all and you substitute program with student, along the line you may have a problem. Now 4, the assessment method applied shall provide an adequate and fair basis for determining whether a student, you understand? So it's the program that you assess that is going to be used in determining the student. So you cannot replace program with a student. It will throw the entire class off gear. So let me hear Professor Kingsley Nyako.
Speaker, thanks. I mean, so if you read 49 from the first paragraph to the 4th one, you see a progression. So you first look at the program, the assessment protocols that you use to assess the program and its objectives. That is why if you come to 4, it is now judging the assessment of the students to the program's objectives. So I don't see anything that deviates from what is captured here, because the 4 now talks about provide an adequate and fair basis for determining whether a student has achieved the objectives and intended learning outcomes of the law program, which has already been captured above with their appropriate tools. So I think that it should stand. Thank you.
I recognize Honorable Che. Okay. You propose it, so we'll come to you later.
Thank you, Mr. Speaker. If you look at the clause very well, the learning outcomes is for the program. The objectives is also for the program. But the assessment is for the student. That is why the earlier rendition, which we approved, is saying that we should put these standards in the student manual. So I will want to support Honorable Daku's proposal that the assessment of the law student shall be designed so as to give effect of the objectives and the intended learning outcomes of the program, because you cannot assess the program to give an outcome of the program. Remember, the assessment which leads to the standardization and accreditation is done by the council in collaboration with GTEC. But here we are looking at assessing the students. That is why we can't use just the law program for both. Here for 51.1, we can keep the law program. 51.2, we can change it to the law student. Then 51.3, we can change the first assessment of the law program to student, then keep the learning level and objectives of the law program. Because you are assessing the student, but the program leads to objectives which you want to achieve. I say so.
Once this is talking about the program and a student, and there is a mixed feeling that where in some places a program should be used and in some places students will be used, I may want to direct it to drafters to use the appropriate terminology. So drafters, you are accordingly directed. I'll put a question on the entire clause 49. As many as are in favor of clause 49 as amended standing part of the bill, say aye. Again, say no. The ayes have it. Clause 49 as amended is ordered to stand part of the bill. Clause 50.
Grading standards.
Mr. Speaker, amendment proposed subclause 1, delete and insert the following as advertised on page 19. I so move.
Our members, the proposed amendment is for the consideration of the House. Any further amendment? All those in favor of the amendment proposed by the chairman of the committee to clause 50 as in LXV, say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. LXVI, chairman of the committee.
Mr. Speaker, amendment proposed subclause 3, delete and insert the following as advertised on page 19. I so move.
Yes.
Speaker, I suggest to the chairman that it's not enough to go the way he's going because we are dealing with different documents. So if you are referring to the proposed amendment, link it to the document and then read the new rendition in full so that we know the new rendition, because I'm sure that would offer members the opportunity.
I don't know why chairman persistently refused to
Yes, there's a
link
winner.
the two documents.
So read exactly, I mean, that is you want to do a fast track. No, read.
Because the new renditions are contained in the winnowing committee document. So it's easy to link it up and read the new rendition.
Mr. Speaker, you earlier admonished that we move on.
Very well.
So, Mr. Speaker, I'm just following your directive. Now I'll come back to basics.
Speaker, let me be your counsel. The fact that you gave directive did not mean that he should do the wrong thing.
This will be very novel. The speaker will have a council who has presiding. Who has presiding? You have a council.
Mr. Speaker, I want to come to your aid. Mr. Speaker, you said we should move on, but you didn't tell him that he should do the wrong thing. That's the point I want him to know. So, Chairman, do the right thing.
Respected Minority Leader, I will. Mr. Speaker, I think that for 50, we are all on the same page. On page 19 of the order paper, as the 50, and then the original bill is the same 50. Then the winnowed bill has it as 53. 53 on the winnowed bill. Why? John.
No, it's 52. You are talking about 52.1. A university shall run a law program.
So you are done with your amendments, right?
No, he's not done.
He's done.
We are done with the amendments for 52.
Honorable members, the indication is that chairman is fasting and it's after 5.
So we should suspend.
So the vice chairman, you have to be very proactive.
50. We are finishing at 50.
But we've done more than 50 already.
Honorable members, what is happening here is that if you look at the new document by the winnowing committee, they are proposing a deletion, the beginning of the clause up to before shall, and they are inserting a university that runs a law program. Then I at the end of the clause, they are adding assessments. So it reads, a university that runs a law program shall adopt in writing uniform grading standards that ensure accuracy, validity, reliability, and consistency in the evaluation of students' performance in assessment. Students' performance in assessment. So with this, I'll ask if any member has a further proposed amendment. All those in favor of the proposed amendment say aye. Those against say no. Honourable members, the ayes have it. The proposed amendment is ordered to stand part of the bill. Yes, now to the entire clause 50.
Yes, Mr. Speaker. So 52.2, where it reads that where more than one law lecturer teaches a group of students, there shall be a reasonable and justifiable correlation among the grades awarded by the law lecturers to ensure fairness to the students. Mr. Speaker, I am a law teacher, and in some cases we teach different groups, and I believe that we shouldn't legislate this. I suggest, instead of this particular provision, we state that where more than one law lecturer teaches a group of students, the lecturers shall set one set of questions for the students. That is my rendition, Mr. Speaker. I believe that stating that you have to have a correlation among the grades awarded by the law lecturers to ensure fairness will be too difficult. Two different lecturers marking scripts. How are you going to ensure fairness among the grades? But once there's one set of questions, then it means that obviously there will be fairness. One set of questions.
How do you relate that to clause 49 that we have taken? Setting a uniform standard and format for conduct of assessment. Because the assessment involves examination.
Yeah. Mr. Speaker, if you read this well, you see that in the end, you are talking about assessment of the students. And you are saying that the lecturers should ensure a reasonable and justifiable correlation among the grades awarded by the various law lecturers. I mean,
which of the provision are you reading?
Mr. Speaker, I'm reading the 52.2 grading standards that of the Winnow document. So at best we can delete that, because you have different lecturers teaching, and you legislate. They legislate that the grades should be similar.
Yeah, so what is the concern? Let's listen to his concern.
Okay.
To the two.
Yeah, Mr. Speaker, my concern is that you are asking several lecturers, by this provision, you are asking several lecturers, you are saying that in awarding grades, okay, there shall be reasonable and justifiable correlation among the grades awarded by the various law lecturers to ensure fairness to the students. And I'm saying that would be very difficult. And so that instead of saying that there shall be a reasonable and justifiable correlation among the grades, we should rather ensure that there is one set of questions. So my proposed amendment, Mr. Speaker, is that where more than one law lecturer teaches a group of students, the lecturers shall set one set of questions.
Wait, let him finish. Let him finish.
So I have put my proposal there.
Yes. Let him finish. Yes.
So, Mr. Speaker,
You belong to no society. You are not with us. We are with Ghana Bar.
So, Mr. Speaker, I so propose
No, let's take the new rendition seriously. You have to move the renditions.
Yeah, so my rendition is that where more than one law lecturer teaches a group of students, the lecturer shall set one set of questions for the students.
There shall be a uniform set. There shall be a uniform
Speaker, the meaning this provision is conveying, I see what is missing. This provision is saying that where several lecturers teach one course, it's one course, like conveyancing. Then you have Afenyo teaching. Hold on. Or let's say interpretation. The Honorable Afenyo Markin teaches interpretation of statutes. The Honorable John Laku teaches interpretation of deeds. Hold on, please allow me. Now, where you have to set exams, the provision is saying that you must work together, okay, so that when you are marking the scripts, you coordinate in such a way that there will be a relationship in the marks that you award. Hold on. Now, because the group of students could be subdivided into subgroups, like group A, group B, group C, the same course, but because perhaps of numbers. So when you are setting the exams, you must synchronize it in such a way that in awarding the marks, one lecturer may not appear to be favorable to the group of students who came under his tutelage. That's what this provision is saying. So if you propose that amendment, it doesn't cure the problem. It doesn't remedy the situation.
Now, practically, let's look at what happened at the university in a particular year. Very well.
Mr. Speaker, so I taught at UPSA, and I was teaching the graduate class. We were 3 different lecturers, all taking the business law program. So somebody doing MBA, MA, but taking the same program. Mr. Speaker, the same course. In the end, the understanding was that let's come together, the 3 of us should come together and set the questions, because the same, and then have the marking scheme. Now, this was not the case in the previous academic year, where my student complained that I taught them and then I was setting questions for the quizzes, then a different lecture and it came to mark. So the complaints more or less got addressed through the new system that was introduced. Mr. Speaker, I think what the respected member for Swami is seeking to do is to bring certainty here. Because, Mr. Speaker, here you are saying that where more than one law lecturer teaches a group of students, so group of students, they are about 200, one lecturer taking 50, another taking 50, there shall be reasonable and justifiable correlation. What correlation? So you said your different question, I said my different question, and say let us correlate. No, Mr. Speaker, this will become difficult to say that there shall be justified correlation among the grades awarded by the law lecturers.
Yes.
Mr. Speaker, with respect,
Of course.
we have already said in 49 or 48 that there shall be a uniform standard of assessment. That's why you initially wanted.
That's why I said let's link this up.
Yeah, Mr. Speaker, This is very problematic. This particular rendition. Exactly. Yes, Mr. Speaker. This
So
thing,
the university lecturers, where
Mr.
you
Speaker,
have,
I'm not done.
you are not done.
Yes.
Okay.
So, Mr. Speaker, I am saying, Mr. Speaker, this is your parliamentarians here. They do a lot of part time. You know, it's only this year that I've not done part time. But, Mr. Speaker,
you
we
have
like
a certificate to do part time.
Mr. Speaker, this year, Mr. Speaker, I said it's only this year, Mr. Speaker. This year, Mr. Speaker, this academic year, which started last year, Mr. Speaker, I will not disobey Parliament. I have always taught based on my clearance here. I only got my clearance last week, so our catch applied. But the previous years, I don't know of others those who have been doing galamsey. Even court, Mr. Speaker, even court. I've refused going to court. I don't sign any process in the firm because I want to wait for my certificate. Luckily for me, I got the certificate last week. So I can now go and teach. I can now go to the law firm. And I can now go to the court and practice. You know, which fees, Mr. Speaker? If a client has paid the fees to the law firm, I cannot benefit from it. I will pay tax. So, Mr. Speaker, I think this too is very problematic. We should go by what John Dako is saying. Otherwise, we defeat the principle of uniform standard of assessment. There will be chaos. This correlation they are talking about, I don't know how it can be achieved. And talking about a justifiable, what will be the test? What will be the test of that justification? So, if two different lecturers, three different lecturers are teaching the same course, the same course, there should be one set of questions. The lecturers should come together, as is done at UPSA, and ensure that they set the questions. As for the marking scheme, it will be standard. But where different questions are being said, then Group A, you have different set of questions, and then somebody is using the same grading, there will be a problem. So, Mr. Speaker, Chairman should have a look at it and then accept what John is proposing.
Speaker, I think